months later, Mr. wasn't doing well either. Mr. passes away.
Ooh.
Okay. And, the son has his hands full, obviously. 2 ill parents, 1 passes. So we were doing the claims paperwork, after everything was done and over, and the son had started to settle the estate and get things in order. And we did the claim form, and we requested a check in the trust's name. Right? The trust was contingent beneficiary.
Mm-hmm.
Well, the company wouldn't do it.
Welcome to today's Retirees with Certified Financial Planner Wayne Maslyk of Great Lakes Benefits and Wealth Management. Anchored in family values, Wayne offers practical advice to help you get the most out of your retirement years. For more information, visit today'sretirees.com. Now, here's your host.
And welcome to today's Retirees with Certified Financial Planner Wayne Maslyk of Great Lakes Benefits and Wealth Management. If you were with us last program, we were talking about beneficiaries and how that process works a little bit. We're going to talk a little bit, kind of part 2, if we can call it that.
Yeah, we also talked about adding some charitable, bequest to the beneficiary line, the designation line.
Sure.
Instead of just to your kids, maybe add some grandkids to the level, and maybe a percentage to the church or charity you've been giving money to along the way.
And you mentioned last time on the last program some ways to do that made sense. And if you missed that last program, you can go to Wayne's website at today'sretirees.com. And from there, you can link to his YouTube channel and watch or listen to those portions of those programs to get some ideas. But we're going to talk a little bit about that today and a little bit more specifics. What is this unknown law regarding beneficiary designation? I mean, the revised code is probably this thick. So
yeah, I learned something in the last couple of weeks that was very eye-opening to me. I've been doing this 28 years.
Okay.
You think you pretty much know most things, especially, we call it basic, but, everyday planning stuff. But, I could make a commercial. We could say, you need to know this little unknown law, or little known law, or unknown law. So call this number.
Yeah, there you go.
Explain it to you, but I'm just going to give it. A lot of people, most people listening aren't clients, right? But you have a lot of clients listening. So, but it's important enough to where they don't even have to come in to learn it. I'm going to talk about it on this show.
Okay.
Okay.
So you're not going to get compensated for this?
No. Well, I might, because people might realize I'm a good resource. They might come in for a second opinion.
That's the key, and we would encourage you to do that.
Yeah. So I learned something. I'll give you this scenario, and it's eye-opening. So we have a couple, long-time client, and they had an account. The missus had an IRA. Okay, had an IRA investment. Okay. And when you have IRA investments, you pick a primary beneficiary.
Okay.
And you pick a contingent or secondary beneficiary.
All right.
Now, the primary beneficiary, if you're married, is generally the spouse, your spouse. So she had listed her husband as primary beneficiary. Okay. And as contingent beneficiary or secondary, she had listed the trust, her trust, her family trust. When you do a trust, if it's a husband and wife trust, it'll either be, say it's Mr. and Mrs. Jones, the Jones Family Revocable Trust, dated blank, blank day, whenever they open the trust. Some attorneys will do a his and her trust, a Mrs. trust,
Okay.
and a Mr.'s trust. They just, each attorney does their own thing. So IRA, primary beneficiary, husband, secondary beneficiary, the trust.
Okay.
Mrs. passed away.
Hmm.
Okay. Mrs. passed. They have an only son. The son, and this person, by the way, were local clients, but they had, gotten up there in age, and the son had moved them to be close to him in Texas.
Okay.
Okay. So Mrs. passes away, and a few weeks later, Mr. wasn't doing well either. Mr. passes away.
Ooh.
Okay. And, the son has his hands full, obviously. 2 ill parents, 1 passes. So we were doing the claims paperwork, after everything was done and over, and the son had started to settle the estate and get things in order. And we did the claim form, my staff did. And we requested a check in the trust's name, right? The trust was contingent beneficiary.
Mm-hmm.
Well, the company wouldn't do it.
Hmm.
So the trust was listed as contingent, and the husband was primary. So we went round and round. They says, no, we could only make the check payable to the estate of the Mr.
Hmm.
Okay, so our argument would be, well, the contingent beneficiary or secondary beneficiary, however you want to say it, was the trust. Mr.'s passed, so the trust is the beneficiary. That makes sense?
Mm-hmm. So far.
Okay.
I'm waiting for the rest of the story.
Yeah, so that's not the way it works. So Mrs. passed, her beneficiary's Mr., but Mr.'s not around anymore.
Right.
Okay? But he was he was primary. So that's his money.
Okay.
That the value of the account is now his.
Uh-huh.
Well, he was sick. He didn't claim it yet. Obviously, that wasn't going to happen. But the way the law is that's his money now. So he's entitled to choose his beneficiary, where that asset is now to go.
Okay.
The problem is he wasn't capable of doing that. And, the son was power of attorney, right? So the son was capable, but the son is taking care of a funeral and a sick dad. And the last thing on the son's mind is to have the dad claim his
Sure.
inheritance and open a new account and name their own beneficiary.
So
we were mad.
yeah, I would think this would be very getting.
Yeah,
very,
it was like, well, this is, this isn't the way it should be because the contingent beneficiary was listed.
right.
So on the other side of the break, I'm going to tell you why this is the case.
Though that's my brain keeps going. How do we prevent this for the future?
It's easy,
Okay. Well.
but you have to know how it works and why. So,
Right.
and maybe we don't want to correct it. And I'll tell you why she might not want it to have that corrected as soon as we come back.
All right. Well, friends, and this, in my brain, this tells me why you need a good financial planner so that you cover all of these bases. You can get a hold of Wayne at todaysretirees.com, or you can call his phone number at 866-626-3990. We'll hear more about this when we get right back.
Double check that. That's pretty good. Yee. Not crying, are you? Let's tighten that and... Ooh.
Wait, what was that?
What? No, don't worry about that. Here we go.
Asking the right question can greatly impact your future,
Are you qualified to do this?
What?
especially when it comes to your finances.
Do you have a question?
Are you a certified financial planner?
Yes, I'm a CFP professional.
CFP professionals are committed to acting in your best interest. That's why it's gotta be a CFP.
And welcome back to today's Retirees with Certified Financial Planner Wayne Maslyk of Great Lakes Benefits and Wealth Management. If you were with us for the first segment, Wayne told us a very interesting story. So if you missed that, we're going to pick up and listen to the rest of the story, as it were. But you can go back at Wayne's website at todaysretirees.com and go to his YouTube channel, and you'll see that first part of this. So Wayne, we have this family that had an IRA. The designated beneficiary was the spouse, who also passed before they could claim their funds. So when you went to the...
And they had a contingent beneficiary named.
Okay.
The trust.
Which was their trust.
Yeah, and it really wouldn't matter who it is, or who the beneficiary was.
But when you went to claim those funds for the family, they said no.
Well, they said yes, but we're going to make the check payable to the estate.
Okay.
That's why it's very important that when you have a beneficiary named, that's the way the check's going to get made payable.
Okay.
Right? But in this case, once Mrs. passed, the assets are the husband's. The contingent beneficiary, that was the wife's choice. But now that the assets are legally the husband's, now he gets to pick who his beneficiary is.
I'm following now. Okay.
Okay, the contingent beneficiary comes into play if the husband were to die before the wife.
I see.
And she never updated who she wanted as primary, then it would go to her trust.
Okay.
In that case, that's what the contingent is there for, if the primary beneficiary passes first.
Okay.
Primary beneficiary passed after she did, so it's his money. It's his job now to do his thing with his money. And the reason for that, one of the reasons, is what if the husband didn't want the trust to get his money? Maybe he wanted it to go, as our previous show, to his charity, and not to her trust or the family trust. Or maybe they had kids from a previous marriage, and he wanted his share of his estate to go to his kids.
Okay.
Where Mrs. wanted it to go to her trust. So once she passes, those are his assets.
Okay.
Okay. Which made sense to me after that. I mean, then I say, okay, I get it. My wife and I go first. My contingent beneficiary was, who knows, some special thing that she hated.
Right.
Say I was going to my boat, the charitable boat fund. Right, but she would never want money to go there, so she would want money to go to our kids. Right, so instead, if she passed after me, it's not going to the charitable boat fund. It goes to her estate, and then our kids would wind up with it. So I could see why that's the case. But the important thing to learn about this is when someone passes, when one of the spouse passes, those beneficiaries need updated as soon as possible. We never put a big priority on settling people's accounts once someone passed, because there's a lot going on.
Right.
People are upset.
Right.
Life change, grieving, may not be able to make wise decisions, may make snap decisions. But it's important, and the reason this was such a bad scenario is because these people had a trust. And no need for a probate estate.
Sure.
The purpose of the trust is to avoid probate. So now, the son is settling the estate as successor trustee, no problems, everything's smooth. Now he gets a check made payable to the estate. Now he's got to open up a probate estate.
Wow.
When the family had the trust.
Right.
So he's got to get an attorney, he's got to become appointed by the court, he's got to open up a bank account in the estate's name, deposit the thing, pay the court costs, pay the attorney, cash the check, disperse it, and now the estate's closed. So he's thinking he has a closed estate, now he has to open up a probate estate.
Wow.
So, this has never happened. I mean, this is something I learned, and, some people may know that this is the law. I do now. But, putting off settling the estate, which I always thought was the right thing to do, to get a grieving spouse to make decisions on death claims and investing money and how do they want to invest it now. It was never a priority,
Sure.
We would talk to the people right away.
Right, but you want to give them some space and time.
We always said, hey, no rush. When you're ready to come in, we'll do all the paperwork. We'll get things squared away for you. But that process in my office will be changing. We will be pushing people to come in a timely manner so it's not a big mess for their estate.
Right. Well, I have a couple of questions, but we're almost out of time. But the first question is, when this was set up, could it have been set up differently to avoid this scenario? Or is this just the way it works?
Yeah, I guess to avoid this scenario, you could have just named the trust as primary beneficiary, as long as the husband was co-trustees, that would be okay. But
there's always
it was an IRA. So if you were to do that, the trust, they're going to make the check according to the title. So they'll make the check, the Jones Family Trust. A trust can't own an IRA. An IRA is an individual retirement account. So the check will be cut to the trust. Now what happens? Tax.
Sure.
Where if it was the husband's name, he just does a spousal IRA continuance, no tax.
Okay.
So that would have avoided it. But, the best way to avoid it is with qualified money like that is you got to come in after the death fairly quickly. But it's rare couples die 3 weeks apart.
Sure.
Car accidents, it could be, a day apart.
Right.
Right? Well, one spouse survived a day. And
be...
one thing the company had copied me state laws, and there's laws on the books regarding this. It's just the way it is. Even if the husband died 5 minutes after the wife, we'd have the same problem.
Wow. These are scenarios, friends, that we really need to pay attention to. And Wayne tells this story as an example of why you need a good financial planner.
And when we come back from the segment, I'm going to also address how to have the highest odds at eliminating this issue in their estate.
There we go. Some good advice. Go to Wayne's website, todaysretirees.com. We'll be back right after this.
Hi, my name's Wayne Maslyk. I'm a certified financial planner and owner and president of Great Lakes Benefits and Wealth Management. I'm making this video because I'd like to offer you, at no charge, a free newsletter that I send to all of my clients and prospects monthly. The newsletter is filled with little tidbits on investing and finances, and we have recipes. But most importantly, I write a personal message in there monthly, whether it's purchasing vehicles, whether it's investing your money, passing assets to your children, trying to lower your taxes, you name it. If it has to do with financial planning, it will be in a newsletter at some point. I keep the information light, though. It's not political. We're not talking economics, nothing like that. It's fun stuff, a little bit about my family monthly, client examples of how we can help people. We won't bug you. All you're going to do is get our monthly newsletter. We keep your information safe. We don't sell it. We don't give it to any other marketer. The sole purpose is to get the word out that I am the go-to source in this area for financial planning.
And welcome back to Today's Retirees with certified financial planner Wayne Maslyk of Great Lakes Benefits and Wealth Management. We've talked a little bit in the last couple of segments about a specific scenario that could happen with your heirs with your retirement, a situation that Wayne recently ran into himself. And if you haven't seen that, go back to Wayne's website at todaysretirees.com and you can watch that segment. But Wayne, we were talking about this scenario where the one spouse had an IRA, they passed, and they left the surviving spouse as the heir or the beneficiary, but they passed soon after. And typically, when someone has a death in the family, you don't make financial decisions quickly because you got to process things.
I mean, in the past, in situations like that, we've had clients wait months, years. We'd get, with them for a review. They finally were ready to talk business and come in and get everything in order, but they lived. Right, so it wasn't an issue. It's never been an issue. I've been doing this, I say, 28, 29 years. So I just never had clients pass, so close together, having an IRA account with the surviving spouse named as beneficiary. So, and if the son had an estate account open, it wouldn't have been a big deal. It's one more probate asset. But they had a trust just for the sole purpose of this. So, what I want listeners and viewers to take away from this is be aware that if something happens, we talked in the show previously, the event, of when we pass or a spouse passes, you cannot dilly-dally. You need to come in. If they're my clients, come in and get with my staff as soon as possible. I used to say, when things settle down and when you're comfortable. Now, no, you got to come in. And if you work with another advisor, you got to go into their office and get things updated. You don't necessarily have to make decisions at that time. You can just open up the new account, get it in your name, have the same exact investments you had before. Just update the beneficiaries. They need to know that for their kids should know that. You listeners and viewers out there, your kids need to know that if something happens to one of you, you need to get with their advisor and get things updated. Like in this case, the husband wasn't going to come in. He's sick, right? So the sons, the daughters of you guys, the executor, executrixes, the successor trustees, they need to know when a death happens that these things need updated. In case we're up in a nursing home or not doing well, it's up to our executors and power of attorneys and co or successor trustees to get a hold of the advisors and come in and make changes.
So if this person had a power of attorney, could they have made this change?
Of course. Yes, sir.
So that could have been eliminated if they would have just been on the ball.
Yeah, but in this case, it's just one of those weird things. But I could see if it was 2 or 3 months out, people don't, they take a while to come in after an event like that. But, it's important to get in. What's also important is if you're a child of somebody, like your mom and dad or my mom and dad, you need to be aware of this. So when something happens to mom or dad, you got to get on it. Because a lot of times the parents don't bring the kids in the fold. The kids don't even know if they have a will, or trust, or they have no clue, the beneficiaries, and a lot of times they don't even know what mom and dad have. That should change because it's just going to leave them a mess. The kid that's settling the estate for mom and dad. So they need to get involved. Just need to, cut the shyness and don't want to step on mom or dad's toes, and you need to get involved in their estate because you're the one that's going to be handling it. We talk about my newsletters and that. I write an investment letter to my clients every month, the people that have money in my portfolios. We talk about my newsletter all the time. That's kind of, touchy-feely, family stuff. There's recipes in there. There's some good tidbits in that. But my investment letter that I send to my clients is detailed stuff. And we get specific, a little bit politics, but taxes, government, investments, the market, the economy, the whole thing. And I wrote in that investment letter this month that, they need to consider getting their kids my newsletter. So so they become familiar with me. They learn about how I do planning and who I am and my staff. So when something happens to mom and dad, they know to call us, ASAP.
Sure.
To get, started on the estate, so they're not left with a big mess. So keep your kids in the loop, especially the ones that are going to handle your estate, and get in the loop with your parents if you're the one that's going to be handling their estate.
Sure. Especially I can see as you age, I'm a little older than you are, these things are more top of mind for some folks that, we don't expect folks in their 40s to depart, although it happens.
But folks in their 40s can be in the loop with mom and dad, with their mom and dad in their 60s or 70s.
Right.
It just, you just don't put it off. It's just, because it could you could have a mess.
Sure.
And or bad things can happen tax-wise, or assets could end up going to where they shouldn't have went. It's just unnecessary if you stay on top of it.
Right. And that that's a good thought even though you're working with a financial planner like yourself, those regular reviews so that you can pay attention. Mom and dad aren't doing as well as they used to be.
Let's look at their will. Let's look at their trust. Let's look at their accounts. Let's get from the companies where their money's at the beneficiary designations. Who does mom and dad have as beneficiary? How are their bank accounts titled? Are they TOD, POD? Are they in the trust name if they have a trust? All that stuff. And that's why somebody like me helps, checklists.
Sure.
We have checklists like that to just go down the list. Is this in order? And then you just don't miss anything.
Right.
It's easy to do. You just got to take the time to work with a certified financial planner professional. Come in my office, and roll up our sleeves and get to work on it.
Right. And those are, sometimes it might be a little bit difficult to think about that because, mom and dad are going to be here forever, but in reality, we're not going to be here forever. And we need to take care of business, as it were. So if you have that need, and I would encourage you to go to Wayne's website at todaysretirees.com, pick up the phone, go in and see Wayne and his staff at 866-626-3990. We are out of time. We'll see you the next time.
Thanks for tuning in to Today's Retirees with certified financial planner Wayne Maslyk of Great Lakes Benefits and Wealth Management. Visit todaysretirees.com or call 866-626-3990 to schedule a no-cost appointment with Wayne. Today's Retirees is brought to you by Great Lakes Benefits and Wealth Management, family-focused retirement and tax planning services, anchored in family values. Information and opinions discussed on Today's Retirees do not necessarily reflect the opinions of this station. Opinions expressed should not be substituted for individualized consultation with a qualified financial advisor. For specific information, call 866-626-3990 or visit todaysretirees.com.